Let's start with the arguments. First up, James Campbell for Ms. Chiles.
Thank you, Mr. Chief Justice, and may it please the court. Colorado forbids counselors like Kaylee Childs from helping minors pursue state disfavored goals on issues of gender and sexuality. This law prophylactically bans voluntary conversations, censoring widely held views on debated moral, religious, and scientific questions. Aside from this law and recent ones like it, Colorado hasn't identified any similar viewpoint-based bans on counseling.
Mr. Campbell gets right to his point. Colorado has criminalized minors from seeking their goals on issues of gender and sexuality. He alleges because those goals are state disfavored or not politically correct.
These laws are historic outliers. In NIFLA, this court protected professional speech, highlighting the dangers of censoring private conversations between professionals and their clients. And this court rejected by name 2 lower court decisions upholding laws like Colorado's. But the 10th Circuit gutted NIFLA's speech protection.
NIFLA refers to the Supreme Court case, National Institute of Family and Life Advocates versus Becerra, Attorney General of California. The case involved the California Reproductive Freedom, Accountability, Comprehensive Care, and Transparency Act, or the FACT Act, which required that certain notices be posted in clinics that serve pregnant women, including the fact that California provided free or low-cost services, including abortion. The court held that the license notice likely violates the First Amendment.
Colorado insists that its law is subject only to rational basis review. Yet that would allow states to silence all kinds of speech in the counseling room, such as disfavored views on divorce or abortion. If heightened scrutiny doesn't apply, states can transform counselors into mouthpieces for the government.
Now, Mr. Campbell argues that since the Colorado law impacts a freedom protected by the First Amendment, strict scrutiny should be applied, while Colorado believes only rational basis review is required. This argument falls back on the court's interpretation of judicial review, setting a standard of how hard a government must work to infringe on your rights protected by the Constitution.
Here, Colorado can't satisfy any level of heightened scrutiny. It didn't seriously consider any less restrictive alternatives, and Colorado can't prove harm because it hasn't cited a study focusing on what's at issue here: voluntary speech between a licensed professional and a minor. Nor can Colorado deny that many people have experienced life-changing benefits from the kind of counseling that Ms. Childs wants to provide.
Remember this question of Colorado proving harm, as it will become very important later.
First Amendment doesn't permit Colorado censorship. I welcome the court's question.
Mr. Campbell hangs his argument on the Colorado law violating the First Amendment's free speech clause, except the First Amendment says no such thing. It reads, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press or of the right of the people to peaceably assemble and to petition the government for a redress of grievances. You see, the First Amendment prohibits Congress from making laws that abridge the freedom of speech, not the states. That's not to say this Colorado law doesn't violate the Constitution of the United States, just not the First Amendment. We'll get into the real violations later.